Begin.
There is nothing more convincing to a jury than a live human being who takes the stand, points her finger at the defendant and says, "That's the one." Yet DNA exonerations have shown that approximately 3/4 of the innocent persons involved in mistaken identity involve eyewitness identification. With these kind of facts known to this court, that's why in State versus Schutz, this court overruled Galloway and said that expert testimony regarding eyewitness identification is within the discretion of the district court to admit. Our rules say that, our Rule 702 says that a witness who is qualified as an expert by knowledge, skill, training, and education may testify in the form of an opinion or otherwise if that expert's scientific, technical, and otherwise specialized knowledge will help the trier of fact understand the evidence or to determine the issue or the fact in issue. The eyewitness identification experts provide the jury with the tools to evaluate eyewitness identification. Experts use two terms of art, which I think were confused in this case. That is of credibility, which goes to the truthfulness or what the person testifies actually believes that they saw, versus reliability, which goes to the accuracy as reflected in the real world.
An offer of proof made, correct? Yes. And in that offer of proof, there was quite a bit of testimony about things like why it's not the best practice, or if you're going to do it, the best practices, like 6 color photos and other things. Was there also part of her testimony, or the person's testimony, did he or she comment on the victim's reliability?
Commented on the specific victims. She always kept everything, what I kind of consider like up in the cloud, or just results of scientific study. So she talked about the best practices and how, other things where it was all the result of, scientific study and literature and what they show. She never spoke about Petty or Wilson, and the results, or how this affects their testimony or how conclusions from it. But knowing these scientific studies and other aspects, the jurors would have used those in evaluating whether they felt that the testimony by Wilson and Petty was reliable. It wasn't a question about their credibility, because credibility, no one's doubting that they were credible, because generally these eyewitnesses, they believe what they're saying. And that, in some respects, is the problem, because it makes, this was one of the things she was going to get into, was malleability of memory. And, these witnesses were a prime example of, so first they saw the photo array.
Up front, what was wrong with that photo lineup? What did the officer do wrong?
Well, first of all, he never gave an instruction ahead of time saying that the person may or may not be, the suspect may or may not be in it. He didn't tell them that regardless of whether either the women chose someone, they would continue the investigation. Those are like two aspects that they like the officer to tell. It wasn't a blind show up or photo array. In other words, you have an officer or someone who does not know who the suspect is present the photo array, so they don't, give off any vibes about who the suspect is. And so in this situation, the other aspects of the photo array is, if you look at the pictures, the first picture and the fifth picture are much closer to the camera. And Petty herself says, well, that the photo number one, which is the defendant's, she said that stood out to her. Well, you're drawn to it because it's bigger. And so that's always a concern. The copy I have is a black and white, but so I don't know what the color background looked like, but some of the testimony was his was a driver's license ID, where the others were taken from gel pictures. So his photo was definitely different. And Petty says that his photo is different.
It's sort of the same issue as that may come up as Park came up in the previous case. Why is it this harmless error? I mean, I guess I question why the prosecution below made such a big deal to keep this expert out. I think that probably created an appeal, or it definitely created an appeal. But having said that, how would this expert have really swung things, particularly where you have the situation where a lot of the incriminating evidence was focused on this sort of distinctive vehicle that the defendant drove, this Toyota that had this distinctive damage and the way the car sunk, and then had a license plate that was almost exactly identified by one of the two complaining witnesses. So
Brief addresses this to an extent, and it talks about that there's never harmless error, that, everything is tainted by the fact that the brief, from the moment of the identification, everything's, done to sort of the blindfold and to fit the case.
an abstract argument, but this is not a case where everything, the only evidence you had was the identifications that were done based on these photo lineups.
Okay, that evidence, that was strong. But you have to weigh this all, the jury has to weigh this all together. They should have been able to hear the expert's testimony and weigh that with everything else and then make their decision. Well,
How did that make the trial prejudicial? Wasn't there plenty of evidence of your client's guilt anyway?
client's innocence. All you have to do is look at the jury notes, which I did not regretfully talk about in the brief. But if you look at the jury notes, the jury was split 7-5 on Wilson and 8-4 on Petty. So these people were not convinced of the defendant's guilt initially. And so if that evidence had been presented, there's a strong likelihood that it could have gone, the other way. It was a tipping point.
A question about what your proposed rule would be on admissibility. And I know different jurisdictions have addressed this in different ways. It's an abuse of discretion standard. So what are you proposing would be the rule, and in what circumstances would the district court abuse its discretion in disallowing this kind of testimony?
Well, it should always be an abuse of discretion, but there's a lot of discussion out there that whenever you have an eyewitness identification of a person not known to you, that expert testimony should come in. Also, jury, and it should come in. Also, it should be supplemented with, not substituted, with jury instructions that appropriately address eyewitness testimony.
So in what cases would it be an abuse of discretion? Because it sounds like the rule you're advocating for is the district court should just always allow it.
Situation where the person is known, where if you say, like it was your sister and you identified him, you know that person. So eyewitness identification is not going to be helpful. In fact, in one of the cases, and I don't remember off the top of my head, the person, the court said it didn't really matter because the person.
Where the district court Let's assume the category of cases with unknown or defendants that the victim is not familiar with or the witness is not familiar with. Other in that category, on what grounds could a district court deny it?
Should come in, but there's an article with 2020 article by Gary Wells that is cited in the briefs about identification, where he kind of backs up a little bit and says, you know, because he's been the big proponent in all this, but he backs up a little and says, if you have an absolutely pristine identification, all the instructions are read appropriately, nobody says ahead of time, I got the victim in here, or the perpetrator, all of that, and he doesn't, to my memory, really say what that pristine is, and we know it wasn't in this case. He says they are more accurate, but only for the very initial identification. Every identification after that, subsequent identification after that, doesn't count. Only the very initial one.
Counsel, I think you mentioned this early on, but to Justice McDonald's point about categories of expert testimony that might not be admissible or might be an abuse, certainly you wouldn't suggest that this expert could have made a direct evaluation of these witnesses, right? Okay, and sort of in what we do with the child sex abuse situations, where you can't have either direct vouching or consistent with vouching, indirect vouching, right? Those would be off.
In the cases like State versus Jackson, where Wells goes a step too far and comments on the testimony as being.
We go a step too far. One of the questions that was asked, and did you recall, and this is of the expert that was proposed, and did you recall or review a phone call from one of the complaining witnesses as well? Yes, audio phone call to dispatch, I believe. Would you tell the court the issue that you noticed with the lineup procedures in this case? And there was an objection for vouching and sustained. It was sustained within an offer of proof. Isn't that an indicator that the expert was going to talk about this case, these people, and not just general what happens in the eyewitness world?
Number one, it was sustained, so it never came in. I'm not sure. I guess I don't remember that portion of it, but it doesn't come in. So I'm not sure what the expert was going to say.
The point that the defense attorney seems to be making is he wants this person to testify. Well, the judge stopped it at that moment because it was without the jury. But the whole purpose of that offer of proof was to show why they want their witness. And isn't that an indicator that it was to talk about the case?
I don't know the answer because I just don't have the fulfilled discussion in there. But I mean, when it does, I mean, you had cases where they had, like they were going to talk about the study that used the same lineup, and then, but they didn't know, the jurors didn't know it was the same lineup or that was used in the same study as a case in question. And then that was okay because it was still talking about the results of the study. But at the same time in Jackson, where Dr. Wells talks about it, when the prosecutor asked, was that person's identification reliable, that went too far because it specifically talked about that person. So, you know, I mean, it's very possible, Judge, that what you said is true, but we don't quite know because it never came in. And even if it had, I mean, they could have just said, you can't do that. But everything else that you can talk about. And the strange thing is about this is that the district court didn't just limit the like confidence discussion, but she excluded everything. She said everything goes to credibility, and so it was excluded. I see my
District court, okay, fine, we'll fillet this testimony that was offered in an offer of proof, and we only want to do the portion that has to do with in general terms. Was that argument ever made?
Actually, the defense counsel, she offered at one point to just talk about present evidence on best practices and not talk about the confidence relation to reliability. And the court said, no, even the best practices discussion goes to credibility, and she refused to allow it. For the reasons stated here and in the brief, we respectfully request this court reverse his conviction and remand for a new trial. Thank you.
May it please the court, counsel. I'd like to start with some areas where I think the defendant and the state can agree. The first is that I think we would both agree that an expert can testify to general factors that impact an initial identification of a defendant. And I think that we'd also agree that they could talk about the general best practices of a photo array. I think we would also agree, especially based on what was just said, that an expert could not come in and directly say a victim's testimony or a witness's testimony was not credible based on ABC factors that were present. I think what we're really here to discuss are the parameters of what an indirect opinion is on credibility in these types of cases. And that's why the state believes the child sex abuse cases are so correlative to this issue because sort of the same issues arise. And the state believes that an expert can come in and testify to useful, non-conclusive information that helps a jury make a credibility determination. But what an expert cannot do is come in and pass judgment on a victim or witness's credibility in the guise of an expert opinion. And when you start matching up, just like in the child sex abuse cases, factors that are part of an initial identification and factors that in fact happened in this case, and then you have an expert who goes a step further and says, we know that when those factors are present, it leads to an unreliable or even false identification, which is
Matching up kind of exactly what the state does in the child sex abuse cases. You'll have a child that hasn't talked to anybody about the incident for 5 years, say, and so then you have an expert come in and say, well, delayed disclosure is very common and it isn't a reason to disbelieve the narrative that's been given by the person claiming that they've been abused.
especially if you look at the Court of Appeals opinions that have ruled on this, like Trinagel and Pitzenbarger, the state has been extremely limited about the type of testimony it is permitted to present in these types of cases. And if there is any type of mirroring.
I haven't read it. All right. I mean, I got enough trouble keeping up with our opinions and their published opinions.
And I say that because that's where most of our cases go. And so we've been following those rules from the Court of Appeals for years now, because if we don't and we run afoul of them, we're redoing child sex abuse cases. And so the testimony of our experts now in child sex abuse cases is extremely general and unspecific to the child in that particular case. And
this expert go too far in the offer of proof on this matching up?
the offer of proof personally got off on the wrong foot initially when the first question was, what do you look at when you're determining the reliability of this evidence? I think, and then they start just going down that line. Now every question is whether or not this identification was reliable, what factors play into whether or not it becomes a reliable.
Credibility, though?
In these particular cases it is, and I'll explain why. There are certainly cases where experts testify about reliability of certain evidence, maybe about how evidence is collected or tested. You know, maybe in an OWI case, we talk about, was this blood test blood sample reliably tested? I think it's fundamentally different when the human is the evidence. Then what they are testifying to can't be spliced out as an independent piece of evidence. Their reliability in telling you, I mean, if a jury is told by an expert that if XYZ happens in a case and XYZ happened in this case, that leads to an unreliable or false identification, then the expert has given the jury the answer. This is an unreliable and false.
Physical issue. So let's say, the evidence would show that humans can only identify a face at a distance of no more than 350 feet. And you have an eyewitness identification at 500 feet. Are you saying you can't get an expert on the stand to say that it's physically not possible based on our current understanding to make that identification?
Case you could do it, but that I think is different than the information that we have coming in about these, because that would be an impossibility, right? We know that humans, after a certain point, can't identify someone after a certain amount of feet. The variables and factors that experts in these testify to aren't like matters of fact, because
Expert opinion, which our rules say the credibility given to the expert opinion is for the jury. I mean, the jury could listen to an expert and say, well, I don't believe that because I'm a hunter and I can see people from 700 feet or whatever. But those are all fact questions. I don't know why that goes to admissibility.
admissibility for the same reasons that it does in child sex abuse cases. We don't allow experts to get even close to saying that type of information in those particular cases. If you look at, the case, one of the cases that we rely on a lot, Trinagel, an expert in that case testified simply that the child acted appropriately during the interview. And then the result of that was, well, actually that meant that the expert was saying that they didn't think that the child was coached, which meant that they believed the child was telling the truth. It was gloss on gloss. And that's sort of the situation we have on here when we're talking about.
Specific about that child, though, wasn't it?
Also an indirect comment still.
Correct. I mean, that's testifying as to the specific witness. That's not, the analogy here would be, well, I saw the video of this expert witness identification that was performed, and I don't think that the witness there was acting appropriately during when she identified the defendant as the person who was committing the indecent exposure.
Cases from the Court of Appeals that the state has been relying on all these years, but that is considered an indirect comment on credibility from the Court of Appeals. And so that is where the analogy comes in with what I'm talking. Okay.
You just look at, an expert opinion that you should have a double-blind photo array. The officer running that with the victim shouldn't know who the suspect is. Is that expert opinion admissible?
I think they could say general best practices for, creating a photo array that is non-suggestive would be to do a double blind, would be to do, the monologue beforehand about, how you can choose or not choose, and then the non-confirmation of the choice would all be things to say. It's the step further that the state disputes. If you don't follow this, then the identification is wrong, or, we know that it's wrong.
If you would concede would come in on this offer of proof, but the whole thing is kept out because parts of it may have gone too far, is that an abuse of discretion?
Because in this case, the district court ruled that some things like the reliability testimony was not admissible, but it was leaning towards permitting the testimony about the photo array practices. But if you read the argument from counsel, she continually brings it back to the reliability information. She intertwines them. And the court even calls her out on that and says, every time you start talking about the photo array, you start talking about reliability, and I don't see the difference now between the two. And I think so based on that, I think in this case it wasn't an abuse of discretion because what the information the court was getting based on the argument was that these two things were so intertwined that the defense wasn't going to be able to unentwine them.
Liability, what all of those things go to, that the fact that the officer knew who the suspect was, problem.
Not a problem, except that the defendant didn't make that specific argument in this case, and certainly didn't make it on appeal. The argument here is that this is wholesale admissible. There's no part of the testimony in which the defendant identifies in his brief that should have been admissible. He doesn't splice out these parts should have been admissible even if these conclusions weren't. So I think based on what the argument was below and what it is on appeal, we don't have that before us and able to determine which pieces of this would have been acceptable.
Sense to Justice McDermott's question. The whole point of the defense expert on eyewitness testimony is to raise questions regarding the reliability of the eyewitness identification, not the credibility of the witness who may firmly believe that he or she saw, A, B, C. So it always goes to reliability, but you're saying the fact that it goes to reliability makes it inadmissible because it's indirect comment on credibility?
Cases, because I just want you to imagine this.
What are these cases?
Identification expert cases where the person is the evidence. And I say that because
Cases.
eyewitness identification expert.
Would somebody have an eyewitness expert where eyewitness testimony was an issue?
Into evidence. I just mean, maybe we're talking past each other, I don't know.
It always goes to reliability, and you say that's impermissible.
I just want you to consider this for a second. If someone came up to you and said, I find that person unreliable, or I find what that person saw unreliable, or the story that they're telling unreliable, would you find that person to be a credible, would you trust that person? And I don't think any of us would trust someone once we're told that their statement is unreliable. I've said it. I just believe it's different when it comes to.
One of our cases that is published, State versus Montgomery. So that was one where there was the issue on appeal was a sex abuse case, and the defendant argued they were not permitted. Do you remember the case? Might have been your case. But the defendant argued that the child victim there was confusing victimization by the defendant with victimization by another person, and the defendant was precluded from bringing in the evidence of victimization for another person. We reversed and said that was error. The defendant should have been allowed to do that. And then we specifically said Dudley, our big case about vouching, would not bar Dr. Jones Thurman's expert testimony that child victims generally may conflate their memories of abuse.
Wasn't that a rape shield case? Is that correct? Yes.
The reason to bring that in was so you could then add in, insert that expert testimony, which that the child victims generally conflate their memories of abuse. So why can't you say, how is that any different? That seems to be more, the same kind of thing we're talking about here. That people who were shown lineups tend to make unreliable or less reliable identifications when procedures X, Y, and Z are not followed.
You're saying, and we just take a different position. And since my time is running out, I do want to address Justice McDonald's question to the defendant about what would constitute abuse of discretion in these cases. And I think that is when we have to contend with Schutz and what this court meant in Schutz, because that was a case, obviously, that overruled the per se exclusion, but that was also a case where the only evidence that the state introduced to tie the defendant to the crime was uncorroborated eyewitness identification testimony. You know what I'm saying. And this court favorably cited People v. McDonald from the state of California, which stated that it is only an abuse of discretion to not permit this type of expert testimony when it is uncorroborated eyewitness testimony.
Before your time runs out. I kind of understand the reasoning behind it, but I kind of don't. So in this sense, and here's my question. It seems odd to say that the admissibility of the defendant's expert is contingent on the strength of the state's case, which is kind of what those cases say, I think. And I think a majority of jurisdictions have that rule. But I'm not sure it makes sense to me, so why do you think that would be the right rule?
I think there's actually a small distinction between abusive discretion and non-abusive discretion. So I don't think those cases disallow a district court from allowing an expert to testify in cases where there is corroborated eyewitness testimony. They could certainly still, under the facts of those cases and their discretion in that particular case, allow that type of testimony. It's only when they disallow it, when there's uncorroborated eyewitness testimony, that it is an abuse of discretion. So it's sort of not a threshold for admission, it's just the threshold for the abuse of discretion.
Like, let's say you had crystal clear video of the defendant's face, and the jury could look at the video and see it. There's no reason to allow. Is that kind of the thought behind that?
Behind that, where there is other evidence that corroborates it, so the jury it isn't as relevant or necessary for an expert to come in and tell the jury about these factors because other evidence already exists that makes it more credible.
Turn on a 403 type of balancing?
I think that could be it. I mean, in Iowa, that has sort of traditionally been the route we've gone because we don't have the initial gatekeeping functions of Daubert, where if it is crossed that line, it is the more a 403 analysis of either prejudice, confusion, waste of time.
Their 702 rule about admissibility of an expert and then just do that balancing. Why add in this extra corroboration element?
I mean, I think you could go both ways. I mean, I think that would be more traditionally the way we do it in Iowa. But it's sort of remiss not to note that this court did, favorably cite that, type of standard in that case. So at the very least, I do think in terms of giving guidance to the district courts about what to do, there does need to be a clarification of what type of standard we're using for the admissibility of this evidence.
Harmless error generally, and specifically, should we look to a juror notes that show they're divided in evaluating whether error was harmless?
I don't remember that evidence in this case, and I would typically say no, we have rules against that type of invasion into the jury's province. In terms of harmless error in this particular case, the only testimony that Dr. Macklin provided was about the photo arrays, so it wasn't about the initial identification, it wasn't about the post arrays. It was simply about the photo arrays. So in this particular case, we have a person who essentially followed all of the procedures, save the double blind. But the officer in this case did tell the victims, if you're not sure about someone, don't pick them. Don't pick anyone. And he didn't confirm their choices. So there wasn't that, after they picked them, he said, yes, that's the guy. And in this particular case, we have one victim who wasn't able to choose someone from the photo array, which seems to suggest that it isn't a suggestible array because we have someone who wasn't able to do it. And I do want to say, I have seen some confused faces up here, and I had a confused face earlier. There are two trial transcripts in this case. There were two trials that took place because he was granted a new trial and the second trial took place. There is an offer of proof in the first trial and an offer of proof in the second trial. So what we want to be looking at is the offer of proof in the second trial only.
Oh, that's the one where the jury sent a note saying, can we be hung? And then they disclosed the votes. And then the judge kept them until 7 o'clock and then they reached a verdict. Is that the second trial? That's what we're talking about, right?
I don't remember that piece of evidence. I'm sorry. I don't remember if that's the first trial or the second trial. I don't remember seeing that note, which makes me think it's the first trial, but may not be. So I just want to make sure that we have that clear in terms of because the offer of proofs in the two trials are very different. So I do want to direct you to the second one. For all those reasons, we'd ask this court to affirm the defendant's conviction. Thank you.
Okay, sorry. Okay, those jury notes are at D0236 and D0238. I'm pretty positive they're not the first trial, they're the second trial. Anyway, I believe the state and the district court are still convoluting reliability and credibility. And again, all their examples seem to be going to a specific witness when they testify about credibility. So, like in the children don't lie, when the children don't, or in the cases, I should back up, to specific witnesses. And then in the sex abuse cases, they go to an ultimate question, like children don't lie. Well, that's the ultimate question in the case. And they're talking about, or in Tingle, she's talking about a specific child, and she's talking about coaching. And she says that, children who watch SpongeBob are not lying. So she's talking about, because this child specifically talked about watching SpongeBob, when she said children who watching SpongeBob aren't lying, she was going to that child specifically. And that's where the sex abuse cases kind of tie into the specific witnesses.
Problem here in the scope of what the defense counsel tried to get in here. The state seems to kind of agree that some of these questions may have been okay, but kind of looked at as a whole package. The district court generally got it right. What's your take on that? Did the district court need to sort of parse out, okay, you can ask these three questions, but not those three? Did the defense kind of make its bed here in asking for all of it?
I don't believe under the facts of this case that it was, because it was going, definitely to the best practices, but also then going into the confidence does not necessarily mean reliability. I mean, that is a statistical thing that they know, that people could have extreme confidence, which usually they gain through time, and it has nothing to do with the reliability of their case. And so that's just a factor that they should be made aware of. It's not telling them that if a person is confident that they're wrong. It's just saying you need to be aware of this fact, and you need to have it in your toolbox when you evaluate all the evidence and reach your decision.
Discretion for the district court to apply the wrong legal standards. So if this judge thought testimony about reliability, if that was mistaken as vouching, is that a reason to reverse?
Yes. I mean, if they just misunderstood the whole, underlying of expert testimony, then they have abused their discretion.
A little bit of what Justice McDermott said. If the defense at the trial level was insistent on the whole ball of wax, they wanted everything with the expert, including some things that the court said that's going too far and was beyond just playing the parameters of best practices, would you agree that that was within the judge's discretion to say then no? If you can't operate within these lanes, no.
It is within the judge's discretion, but I think that the judge would have been incorrect. Oh.
Expert was going to go into areas beyond just best practices and would not commit to staying within a certain line of questioning. Can't a judge say, then I'm not going to let that person testify?
I think, yes, but that's not what was happening down below.
The case. If a judge said part of the testimony is inappropriate, part of it's okay. But if the defense wanted all of it in, isn't it okay for the judge to say then none of it comes in?
Yes.
Providing guidance to the district court, what should what role, if any, should corroboration or lack of corroboration play on the admissibility of an eyewitness expert?
I turned to the amicus brief. I think they did a great job in discussing that, but also there's such a danger in corroboration that it's tainted in, going from the initial identification then to how you can make things fit. And so, like the sunglasses. She saw the sunglasses. That post was 12 years old. I don't have a pair of 12-year-old sunglasses. And I'm just, but she sees that and she's like, oh, those are the sunglasses. So that's an example of where there's corroboration, but is there really corroboration? Because is she really making what she saw fit her memory? And I went to,
We're well beyond the time.
Petty made a statement. She said, I was very anxious, and so the answer to Mays's questions might not have been entirely accurate. But now I've had time to consider and things further, and I realize what had happened to me. And then, yes, things became more clear. And that's the danger that we face when we don't allow the expert testimony. Thank you.
It's hereby submitted. And we are going to take a brief pause. The attorneys for the next case can go ahead and get situated, which is Iowa Northern Railway versus Floyd County Board of Supervisors and others.